it really rolls into the next story we're going to talk about too, because there was also a federal judge in Connecticut that upheld the state's assault weapons ban and magazine limits under very similar reasoning, right?
Yeah, so we have a federal ruling denying a preliminary injunction. So the gun rights group in this case requested a preliminary injunction on both the assault weapon ban and their ban on magazines capable of holding more than 10 rounds. And like you said, it's sort of become the go-to blueprint for upholding hardware bans in this case. We've seen it happen at least 4 other times now by federal judges under similar circumstances where they say, well, the plain text of the Second Amendment says this, and, the Supreme Court previously said in Heller and Bruin that guns that are in common use are covered under that plain text. But if you look at the empirical evidence, magazines that hold more than 10 rounds and AR-15s are not actually used commonly for self-defense. And so therefore, the plain text doesn't cover them and they can be banned legally. And that's almost verbatim what this federal judge ruled in this case. And we've seen it in a few cases in the past. So this has clearly become the go-to blueprint for regions, but more specifically judges looking for ways to uphold these hardware bans.
Yeah, you got those two arguments side by side oftentimes in these cases where either they argue the affected guns or accessories aren't covered by the plain text, or that there's some the development of new firearms technology has led to a modern problem that wasn't foreseen by the founders, and therefore you can use a broader analogy. Those are sort of the two main arguments that you see now.
I would say the judge in this case ruled that first part that, it's not covered by the plain text. But even if I did decide that it was covered by the plain text, this is how it would happen. Well, it's an unprecedented social concern. And so therefore I can loosely analogize to concealed carry bans on Bowie knives to cover flat out possession bans on AR-15s and magazines.
Yeah, that's what you'll usually see, right? In a lot of these cases where they'll just start with the idea that these aren't in common use for. Well, what you're seeing a lot of is not that they're not in common use, but specifically that they're not in common use for self-defense.
Right.
That is what they'll try to narrow the common use standard to that, even though that's not really what Heller said, or even Miller, which is where Heller got the common use standard from. But they try to make it a much more narrow decision about whether these are in common use for self-defense, and not even just that people believe they're buying these guns for self-defense, but that there actually is evidence that you fired more than 10 rounds commonly in self-defense shootings. That's what most of these judges have done with the magazine restrictions, for instance. You saw that in Oregon as well, where they argue based on very limited databases of public reports about self-defense shootings. If they don't mention that more than 10 rounds were fired by the defender, then the judge concludes that it's not common for magazines that hold more than 10 rounds to be used in self-defense, or at least be necessary for self-defense is sort of the idea they're getting at with this. So, and then they'll do what you mentioned, where it's like, okay, even if that doesn't hold up, I'm going to go to the Bruin test anyway, and I'm going to use this reasoning that has become very popular with how I get to a looser analogy.
Yeah, no, and it's a key distinction too, because it's not just in common use for self-defense, but under some sort of empirical use of self-defense. Like, it's not good enough that gun owners say, I bought this for self-defense. They have to, as you said, sort of pull from public research or some other source to show that they were actually used in self-defense.
Right, which is, again, also different from how Heller interpreted that whole concept, because, they use the idea that people believe handguns are, that they're purchasing handguns out of the belief that they'll be used for self-defense. Heller didn't cite to like a statistical study of how often people use handguns in self-defense. It cited more like polling about why people say they buy guns or say they buy handguns. So, pretty different application, and one that I would be very surprised to see stand up at the Supreme Court if it makes it there, though. Right? That's the tension in a lot of these things is will the Supreme Court take up a case like this? We have every indication that they should or would or are interested in doing that, because they GVR'd several cases in this vein, right? There was the Maryland assault weapons ban case and the New Jersey magazine restriction case, both of which the law had been upheld by the lower courts. The court vacated the lower court ruling, and then remanded those cases back down to the lower courts to rule in accordance to the new Bruin standard. But, it has only been about a year. So I know a lot of gun rights advocates want to see things move faster, but that's not really how the court operates. But it's an open question of whether they're going to come back to this. It seems likely, but it hasn't happened yet.
Right. Yeah. We'll still take some more time for the cases to percolate.